Hello and welcome to the Office of the Information and Privacy Commissioner for British Columbia's webinar, the Personal Information Protection Act, Essentials for Your Organization. Before I begin, I would like to take a moment to acknowledge that I'm speaking to you from the unceded traditional territories of the Musqueam, Squamish, and Tsleil-Waututh Nations. As a representative of an officer of the legislature, I acknowledge that I'm privileged to work with people across many traditional territories covering all regions of our province. It is with deep appreciation that I live and work on this beautiful territory. Today, we're going to discuss one of two pieces of legislation that our office oversees, BC's Personal Information Protection Act. So, here's what we'll cover. We'll discuss our office, including our mandate and our role as an independent office of the legislature. We'll look at access and privacy legislation in BC and Canada, including the legislation that we enforce. Then, we'll focus on the importance of privacy management programs and how you can develop one that fits your organization's needs. We'll also see how PIPA applies in the employment context, including workplace privacy and what information an employer can and cannot collect about their employees. And then finally, we'll share resources and let you know how you can get in touch with our office if you have any access and privacy related questions. First, it's important to note up front that yes, we are the regulator mandated with enforcing BC's privacy and access laws. So yes, that means that we need to hold organizations and public bodies accountable to ensure they are respecting British Columbians' privacy and access rights. But at the same time, we're here to help and to provide education. We welcome calls and emails from members of the public, as well as public and private bodies who are navigating their way through complicated privacy and access issues. And we've prepared numerous guidance documents and tools to help guide you through some of the most common issues we see. As mentioned, we'll talk more about when you should contact our office and the ways we can help at a few points during today's presentation. Here's a brief overview of the Office of the Information and Privacy Commissioner. Our office was first established in 1993, and we're an independent office of the legislature. That means that we are not beholden to any government or political party. Our office is mandated to enforce FIPA, our public sector privacy law, and PIPA, our private sector privacy law. Examples of other independent offices in British Columbia include the Office of the Human Rights Commissioner and the Office of the Auditor General. Although our office regulates the provincial privacy and access laws, we don't actually establish them. The government is responsible for introducing and amending provincial legislation. Our office advocates for amendments that protect and promote the information and privacy rights of the public. FIPA, the public sector privacy law, and PIPA, the one we're here to talk about today, set out the mandate of our office. Some of our primary responsibilities are included here on this slide. For example, the Commissioner has the power to investigate and resolve privacy complaints, as well as appeals related to access to information disputes. We support organizations in managing privacy breaches. We initiate Commissioner-led investigations. We issue legally binding orders. We comment on privacy legislation. We conduct research and train the public on privacy rights and relevant laws. And it's important to remember that whenever possible and appropriate, our office works to resolve privacy complaints and requests for review through early resolution processes. For example, we would usually work with the individual and the organization to resolve the matter as a first step. The majority of the complaints and requests that we deal with are resolved this way. More information about our office's complaints and requests for review processes can be found on our website at oipc.bc.ca. On this page, we outline how organizations should respond when they receive a complaint or request a review, and what role organizations play in the process. There is also a full index of rulings on our website, including orders arising from complaints and requests for review. Finally, we also help organizations in their compliance journey. Through our policy consultations, organizations can reach out to our office for comment on new proposed projects, initiatives, or other proposals to promote compliance and best practices. We also provide confidential consultations to the government on new laws and regulations. Finally, we provide training to organizations and publish guidance to promote compliance with BC's privacy laws. We'll talk more about the process for consulting with our office near the end of today's presentation, but for now, let's take a deeper look at privacy and access laws. So, let's take a look at 5 of the privacy and access laws that are applicable in British Columbia. We'll go into more detail on the 2 laws that we enforce, being the Freedom of Information and Protection of Privacy Act and the Personal Information Protection Act, in a moment. But first, I'd like to touch on the 2 that are fully outside of our mandate. Under BC's Privacy Act, British Columbians have a right to sue a person or organization when they feel their privacy has been invaded, with limited exceptions. This process is administered through the courts. Under BC's Privacy Act, a person can succeed on an action against another person under the Act if they can prove the other person violated their privacy. They don't need to prove that there was any damage from the privacy violation. The Act considers that the violation of privacy is enough. The next is PIPA, or the Personal Information Protection and Electronic Documents Act. This is a federal piece of legislation that has limited application in BC. It applies mainly to federally regulated works and undertakings, such as banks and airlines. For example, if you work for a credit union, then PIPA likely applies. If you work for a bank, PIPA likely applies because it's federally regulated. This act has limited application in BC because we are one of the 3 provinces, along with Alberta and Quebec, to have private sector privacy legislation, which overrides PIPA in most cases. As we'll see in further details, PIPA applies to private organizations, and FIPA applies to public bodies. Public bodies can include both ministry and non-ministry bodies. There are over 2,000 public bodies in British Columbia, including bodies like hospitals and universities. These 2 laws work together from the premise of informational self-determination. In other words, that's the idea that someone's personal information is their own, and that as far as possible, they should control how it's collected, used, and disclosed. One other relevant law for the health sector in particular is the eHealth Act. The eHealth Act authorizes the Minister of Health to establish by order health information banks, or HIBs, that restrict access to personal health information beyond the restrictions in both FIPA and PIPA. Think of it as an extra set of rules. If your organization does health research and you have questions about this act, or the Commissioner's role with respect to HIBs, please contact us and we can discuss your research goals and the OIPC's role. We can also connect you with contacts at the Ministry of Health if it's required. Under the eHealth Act, the Commissioner has power to investigate and, if necessary, issue orders to ensure that the administration of access to information in those HIBs is properly carried out. However, since 2008, when the eHealth Act was first enacted, the Commissioner has not issued an order under that Act. Before we move on, 2 other laws that aren't included here, but that are worth mentioning, are the Federal Privacy Act and the Federal Access to Information Act. These laws establish the rules for privacy and information management for federal government institutions, including those institutions that may be operating within BC. So, now after this legislative overview of BC's privacy and access laws, let's dive into PIPA and its requirements for organizations. We'll start by looking at how PIPA applies to organizations in BC. So, let's look at what organizations fall under PIPA and what we mean when we say organizations. PIPA generally applies to all organizations in BC, and organizations include a person, an unincorporated association, a trade union, a trust, or a not-for-profit organization. It even applies to unincorporated associations like clubs and groups. However, PIPA also has a list of entities to which it does not apply, such as individuals who are acting in a personal or domestic capacity, or a provincial court, for example. So, as we've seen here quickly, PIPA generally applies when organizations collect, use, and disclose personal information. But our next question is, what is personal information? PIPA defines personal information as information about an identifiable individual. That can include anything from their health information to their name, their image, or information about their religion or education. It may also include things like their license plate number, their image that was recorded on a surveillance tape, or even their fingerprint. Personal information can also include information about employees of your organization. Employee personal information has a different meaning within PIPA. Employee personal information means personal information about an individual that is collected, used, or disclosed solely for the purposes reasonably required to establish, manage, or terminate an employment relationship between the organization and that individual. For example, if an employer conducts an authorized search of an employee's office space for drugs or alcohol, details about that search can be considered as the employee's personal information, regardless of the results of the search. We'll look more into employee personal information later in this presentation. It is relevant to note, though, that even if the information can't identify an individual alone, it's still considered personal information if it can identify a person or a small group of people when combined with other available information. We often refer to this concept of combining several pieces of seemingly unidentifiable information together to identify a specific person as the mosaic effect. It's a bit like putting the pieces of a puzzle together. For some puzzles, a single piece may give away what the image is, but for others, you may need to connect several pieces before you can see the image clearly. That's the same for personal information. For example, let's say there's only one pharmacist in a small town in BC. If you refer to the pharmacist's son, then this information is not directly identifiable alone. But if you identify the small town the pharmacist lives in, and the pharmacist happens to only have one son, then the people living in that small town would be able to reasonably identify the person who you're talking about. So, as you can see, personal information has a broad definition under PIPA. However, it's also important to understand what's not considered to be personal information. That includes contact information, which would allow a person to be contacted at a place of business, and work product information, which is information generated during the course of an employee's work. We'll discuss all of this later in the presentation. Finally, it is relevant to note that there are circumstances where PIPA does not apply, even if personal information is being collected, used, and disclosed. For example, PIPA does not apply for collection, use, and disclosure of personal information when it's done for journalistic, artistic, or literary purposes. Or if the federal act, PIPA, or the Personal Information Protection and Electronics Document Act applies, PIPA would also not apply. So now that we've talked about the fact that PIPA applies to organizations, subject to certain exceptions, and that we have defined what is personal information, we'll talk about how PIPA applies to those organizations. How PIPA applies will depend on whether an organization has control or custody of the personal information. PIPA doesn't define the terms control or custody, but our office has found that control includes an organization's authority or ability to decide how to collect, use, disclose, and store personal information, how long to keep that personal information, and how to dispose of it. Our office hasn't issued any decisions that define custody just yet, but similar laws generally define custody as having possession of personal information and some legal right or obligation to it. It's also important to note that control can take a number of forms, even if personal information isn't in an organization's custody. For example, personal information in the custody of a contractor providing services to the organization may still be under the control of the organization through the terms of its contract with the service provider. You can use the following questions to help you identify personal information that is in your organization's control. 1. Is the document containing personal information created by an employee of your organization in the course of their work? 2. Is the personal information disclosed to you through your own collection? Or in other words, have you sought out the personal information in question? 3. Is the personal information disclosed to you by another individual or organization? And 4. Do you rely on the personal information for your organization's operations? While this isn't an exhaustive list, these are all questions that are going to help you determine whether you have control or custody of the personal information. So, now we've talked about what is and is not an organization under PIPA, how broadly personal information is defined, and how important it is to determine whether you have control of the personal information. This all helps us to define the scope of PIPA, or in other words, the extent to which PIPA will apply to your organization's collection, use, and disclosure practices. So next, let's move on to understanding the foundational principles of the legislation. PIPA is built around 10 basic privacy principles that are common to BC's privacy laws and found in most privacy legislation throughout the rest of Canada, as well as more broadly throughout the world. We have the principles up here for your reference, though we won't go over them in detail now. As valuable as these principles are, we have a significant amount of ground to cover today, and these principles will be illustrated in much of what we're going to discuss. Although the 10 privacy principles mentioned in the previous slide have been internationally recognized in laws across the world, it's relevant to note that privacy laws do not usually define what privacy actually is. Privacy isn't explicitly defined in either BC or Canadian privacy laws. Instead, BC's laws set out the circumstances under which you can legally collect, use, disclose, and protect people's personal information. We generally characterize these as individuals' privacy rights under PIPA. Even if we don't have an exact definition of what privacy is, we know why privacy is important. Privacy is often viewed as an enabling right for the exercise of many other rights, such as the right not to be subject to discrimination. In other words, without privacy rights, a lot of our other fundamental rights may be at risk. In this context, it's reasonable to say that PIPA strikes a balance. PIPA recognizes both the rights of individuals and the needs of organizations. This means that the law recognizes that organizations need to collect personal information to provide their core services, and that there may be times when it's appropriate to withhold information from individuals. At the same time, PIPA ensures that this information is collected, used, disclosed, and protected in ways that respect individuals' privacy rights. PIPA mainly provides two categories of rights. First, it's those privacy rights that we discussed, and second, it provides individuals with information rights. We'll discuss these two categories of rights in detail later in this presentation. First, we'll start by taking a very high-level look at the basic privacy requirements under PIPA. At a foundational level, PIPA requires organizations that have control of personal information to designate an individual or individuals to be responsible for ensuring compliance with PIPA. Organizations must also have policies and practices in place that show how they comply with the Act. Organizations must also have a complaints process should someone wish to complain about the organization's management of personal information. Organizations may only collect, use, or disclose personal information with the consent of the individual or where PIPA permits these activities to occur without consent. Organizations must also inform individuals about the purposes for collecting personal information, either on or before the time that they collect the information directly from them. And organizations finally must also collect, use, and disclose personal information only for purposes that a reasonable person would consider appropriate. Now that we've seen what the basic requirements under PIPA are, let's dive deeper into PIPA by starting with the core definitions of collection, use, and disclosure. PIPA does not define the terms collection, use, and disclosure. However, we generally consider collection to be the gathering, obtaining, or acquiring of personal information from any source by any means. A collection can either be done directly from the individual, or it can be done indirectly, such as from their social media posts. Use is generally considered to be the processing of personal information within an organization. This includes accessing, sharing, or handling personal information internally. It's when personal information does not go beyond an organization's walls or staff members. Disclosure, on the other hand, is usually considered to be the process of making personal information available or releasing the information to an outside entity such as another organization. Now that we have seen how collections, uses, and disclosures are defined, we'll talk about one of the core principles of PIPA, the concept of reasonableness. An overarching principle of PIPA is that organizations must take into account what a reasonable person would consider appropriate in the circumstances. This is what we often call the reasonable person test. Factors that would be considered in determining reasonableness include, for example, the sensitivity of the personal information, the amount of the personal information, whether it's likely that the information would allow the organization to meet its intended purposes for collecting, using, or disclosing that information. For example, if an organization was to collect personal information to mail a product to a customer, does the type of information that's being collected support the purpose of mailing the information to the customer? The reasonableness standard may also consider the manner of collecting and using the personal information. For example, if the individual knows the information was being collected at the time of collection, and whether there are less privacy invasive alternatives available. This last consideration doesn't necessarily require organizations to select the least privacy invasive alternative, but organizations should consider the balance between their commercial interests and the privacy rights of the individual when making any decision. This is a very broad concept, so we thought we would use an example. An organization called Clearview AI collected 3 billion images of faces and biometric identifiers across the world and put all this information into a database. The database was then sold to law enforcement agencies and was available to others through trial accounts. Canadian privacy regulators launched an investigation and found that this was not reasonable or appropriate based on the reasonable person test that we talked about. Now that we know what collections, uses, and disclosures are, and what the reasonable person test is, let's talk about another fundamental principle of PIPA, consent. PIPA identifies two types of consent: explicit or express consent, and implicit consent. First, let's talk about explicit consent. Explicit or express consent occurs when an individual willingly agrees to have their personal information collected, used, or disclosed. Express consent can be given in writing, or it can be given verbally. If individuals are not capable of giving consent, an authorized third party can consent on their behalf. There are different types of implicit consent. One example is when an individual voluntarily provides information for a purpose that would be obvious to a reasonable person. This is often referred to as deemed consent. PIPA does not require an organization to provide any written or verbal notice of the collection of personal information in these cases, because deemed consent only works when the purposes for collection are considered to be so obvious that notification would be unnecessary. For example, if an individual wanted to have a product delivered to their home address and they voluntarily provided that address to an online store, the person may be deemed to have consented to the collection of their information for the purposes of delivering the product to their home. The second type of implicit consent is often referred to as consent by not opting out. In some cases, an organization may give an individual notice that it intends to collect, use, or disclose their personal information for a specific purpose. If the organization gives the individual a reasonable amount of time to decline or opt out of the collection, use, or disclosure of their personal information, and the individual chooses not to decline or opt out, the organization is considered to have obtained consent. For example, an individual is informed on the phone that their conversation will be recorded for training purposes and is given some time to decide what they want to do. By choosing to stay on the line, they are consenting by not opting out. However, organizations must take various factors such as the sensitivity of the personal information involved into consideration before choosing to rely on deemed consent. Again, that reasonableness standard will apply. Generally, it wouldn't be considered reasonable for an organization to obtain consent by not opting out when sensitive personal information is involved. That could include sensitive children's personal information, for example, or information that would be maintained within medical records. As a best practice, organizations may wish to obtain express consent whenever it's feasible to do so. Last but not least, it's also important to highlight that individuals have the right to withdraw their consent. The withdrawal of consent is not retroactive, and the organization would need to inform the individual of any consequences of the consent being withdrawn. One exception to this right is if the withdrawal of consent would prevent an organization from meeting their legal obligations, or if PIPA says that the collection, use, or disclosure is authorized without consent. Now that we know the different types of consent and that individuals can withdraw their consent, let's look at how organizations can make sure that they collect valid consent. So, for any type of consent, please remember that 1. Consent does not need to be in writing. However, as a best practice, organizations should either obtain it in writing or create a record noting that consent has been received and describing how all conditions have been met. A record of consent should include, for example, documentation of who provided the consent, when the consent was provided, what information the consent relates to, what the consent authorizes the organization to do, and any limitations that may have been placed on the consent. Second, it's important to remember that an organization cannot, as a condition of providing a service, require an individual to consent to the collection, use, or disclosure of their personal information beyond what would be considered necessary to provide their core services. For example, it may not be allowed to ask people to consent to join your mailing list before they can purchase your products, unless it can be shown that joining the mailing list is necessary to be able to deliver your core products. If an organization obtains consent by providing false or misleading information, or through using deceptive or misleading practices, then it's also important to remember as a third point that consent in those cases will be invalid. Now that we know about the definitions of collection, use, and disclosure, the reasonable person test, the different types of consent, we can put all of these notions together and get to the core of this part of our presentation, the rules around collection, use, and disclosure of personal information under PIPA. So, let's start with the rules for collecting personal information. In general, consent is required for any collection of personal information under PIPA. As well, before organizations collect personal information directly from an individual, they generally must provide an individual with a notice of collection. That notice would identify things like the purposes for the organization collecting the personal information. The requirement to provide a notice doesn't apply, though, when an organization is relying on deemed consent, as we discussed. Again, that's because the collection should be so obvious to a reasonable person, and the individual should be voluntarily providing the information, so the purpose of providing the notice would be unnecessary. PIPA also allows the collection of personal information without consent in certain circumstances. For example, organizations wouldn't need consent when the collection is necessary for an individual's medical treatment and the individual is unable to give consent at the time. In certain circumstances, you can also collect personal information from another source other than the individual. For example, if you wanted to collect publicly available personal information that's prescribed by regulation. People sometimes think that if information is available in a public source, like on the internet or on social media, that privacy rules don't apply, but that's not the case. Publicly prescribed sources are very limited and are defined in the PIPA regulations. They include things like public telephone directories, professional or business directories, public registries authorized by law, and personal information appearing in publicly available printed or electronic publications, which would include things like magazines, books, or newspapers. If the source that you want to collect personal information from is prescribed in the PIPA regulation, then you wouldn't need to obtain consent in those cases. Another type of indirect collection is where one organization wants to collect information from another organization. Organizations can collect personal information from another organization without consent in certain circumstances as well, but they would also have to tell the organization that they are collecting it from what their purpose for collecting the information is. That allows the other organization to decide if they have the authority to disclose it to your organization. So that all sounds a little bit complicated, so let's walk through an example. Let's say there's a local arts nonprofit and they want to collect personal information from a ballet school about some of their students for the purpose of deciding whether students should be given an award. The arts nonprofit is responsible to notify the ballet school of its purposes for collecting the information beforehand. The ballet school then reviews that notice and they decide whether they have the authority to disclose the personal information that's being requested without the consent of the students. The ballet school should ask if there are any other purposes for which the nonprofit is planning to use the information so that they can make this decision. If, for example, the arts nonprofit says they will add the dancer's contact information to their mailing lists, then the dance school should tell the nonprofit that this is not one of the situations where PIPA authorizes disclosure without consent. If an organization doesn't have consent and PIPA doesn't allow the collection without consent, then it's important not to collect the personal information. Now that we've talked about the rules for collection, let's move on to the rules for use and disclosure. Organizations can use and disclose personal information if it fulfills their original purpose for collecting that information that was identified within the notice given to the individual. Organizations can also use and disclose personal information with the consent of the individual, or without consent when PIPA specifically authorizes that use or disclosure. PIPA does allow organizations to use and disclose personal information about an individual without consent in specific situations. For example, your organization may use personal information without consent to evaluate whether an individual is eligible for an award or for a similar benefit. As another example, organizations can disclose personal information without consent when the disclosure is necessary to respond to an emergency that threatens the life, health, or safety of an individual. But remember, if you want to use or disclose personal information in a new way, that use or disclosure must have a reasonable purpose and must be authorized under PIPA. So first, you should start by determining whether PIPA authorizes your new use or disclosure without consent. If it doesn't, then you need to obtain consent from the individual for this new use or disclosure. If you use or disclose personal information without consent and when not authorized by PIPA, then that would be considered an unauthorized use or disclosure of personal information. As an example of an unauthorized use, let's say that there's an employee of a dental clinic who has been hired to manage the clinic's online presence. If the employee uses contact details of patients that they obtained from the clinic's records to reach out to individuals who left negative reviews about the clinic online and ask them to take down those reviews, that would likely be an unauthorized use. As an example of an unauthorized disclosure, let's say you receive personal information about an individual in carrying out your day-to-day work, and then you go home and share that information with a family member or friend. That would likely be an unauthorized disclosure. So this is it for the privacy rules of PIPA. But in summary, first, determine if PIPA applies. If it does, make sure that your collection, use, or disclosure is done with consent or where otherwise authorized by PIPA. And never forget about the reasonable person test. So now let's move on to the fundamentals of individuals' information rights. So what do we mean when we talk about information rights under PIPA? Well, first, individuals have a right of access. That means that individuals have the right to access their own personal information that's held by an organization. They also have the right to know how their personal information is used and to whom and when their personal information is disclosed. In the case of credit reporting agencies, individuals are also entitled to know the sources of collection of personal information by those agencies. As we'll see a bit later on, these rights are subject to exceptions that are set out in PIPA. Organizations subject to PIPA also have a duty to assist applicants. That means your organization must assist each individual making a request, for example, by completing a reasonable search in response to a request, and by responding as accurately and completely as is reasonably possible. In case you decide not to provide access to the information that's been requested, you need to inform the individual of the reasons for withholding the information and the section of the Act which you're relying on to be able to withhold that information. Our office has found, for instance, that if an organization does not provide those reasons, then they have not met their duty to assist the applicant. PIPA also identifies the timeline organizations must respond to requests within. Generally, organizations must respond to a request for access to personal information within 30 days after receiving the request. However, organizations can take an extra 30 business days to respond in certain circumstances. First, if the applicant does not give enough information to allow you to find the requested personal information or document, you may be able to extend the timeline. As a second example, if there's a large amount of personal information that's been requested or has to be searched, and meeting that time limit would unreasonably interfere with your organization's operations, then the timeline may be able to be extended. And finally, if you have to consult with another organization or public body to decide if access should be given to the information and more time is needed to carry out those consultations, then the timeline may also be able to be extended. When you receive a right of access request, you also need to determine whether any exceptions apply to the disclosure of the information in question. As mentioned earlier on, organizations at times may withhold information based on an exception that's included within PIPA. There are mandatory exceptions, meaning that your organization must withhold the information, and there are discretionary exceptions, meaning that your organization can either choose to provide or not provide the information. Some examples of the mandatory exceptions include if the disclosure of personal information could reasonably be expected to threaten the safety or physical or mental health of an individual, whether that individual is the person requesting the information or someone else, and where the disclosure would reveal personal information about another individual other than the person making the request. There are also discretionary exceptions, as I mentioned. For example, if the information is subject to solicitor-client privilege, or if the disclosure of the information could reveal confidential commercial information that could, in the opinion of a reasonable person, harm the competitive position of the organization. This happens a lot more in the public sector under FIPA, but not as often under PIPA. That's likely because under PIPA, individuals only have a right to their own personal information, whereas under public sector privacy laws, anyone can request access to general information, such as a contract or a proposal. It's important to remember, though, that even if an exception applies, in most cases, the organization will be responsible for removing the information that is subject to an exception and providing the individual with access to their own personal information. This doesn't apply, though, if the information is considered to be too intertwined with the applicant's own personal information. If you're unsure what to do when you receive a request, you can call us for help. Of note, if you redact all of the information, or withhold all of the information in other words, and the individual who receives the information is not satisfied, they can ask one of our investigators to review the redactions. If the investigator thinks PIPA requires you to release additional information, they'll call you and talk to you about it. So now that we've talked about the right of access, let's move on to talk about the right of correction. Individuals also have a right to ask your organization to correct an error or omission within their personal information. If you decide that there are reasonable grounds to correct any errors or omissions, then you must correct the personal information as soon as reasonably possible, and you must also send the corrected personal information to each organization that you've disclosed the information to in the year before the date of correction. If you decide not to correct an error or omission in response to a request, you must add a note to the personal information with the applicant's requested correction. So that should give you a high-level overview of the privacy and information rights of individuals under PIPA. If an individual believes that the way you've handled their personal information is inappropriate, or they believe that you've inappropriately responded to an access or correction request, then they can make a complaint to the Commissioner or ask the Commissioner to review the matter. I want to reemphasize again here that the OIPC is a remedial, not punitive body. The vast majority of our matters are amicably resolved between the parties with the assistance of an investigator. This is done through our early resolution process. Now, let's dive deeper into some specific topics that may be particularly relevant or of interest. Let's start with privacy management programs, as they help to set the foundation for an organization's management of personal information that they collect. Although privacy management programs are not explicitly required by PIPA, organizations are required by PIPA to develop and follow policies and practices that are necessary for the organization to be able to meet its obligations under the Act. Having a privacy management program does have so many benefits, though. Like security architecture for computer systems, a privacy management program is the architecture of your privacy compliance. It's like a playbook for your organization to be able to manage and protect your customers' and employees' personal information. In addition, if you're ever speaking with one of our investigators about a complaint or a review, telling them you have a privacy management program is a demonstration of your commitment to compliance, not only to us as the regulator, but also to other stakeholders, partners, or customers that you may have. Not all privacy management programs look the same, though. As mentioned, it's important to remember that privacy management programs are intended to be designed to be scalable, relevant to your business, and commensurate with the nature, volume, and sensitivity of the personal information your organization collects. An independently owned business with one employee who collects limited amounts of personal information, for example, would not require the same level of a privacy management program that a large corporation collecting sensitive personal information across the province would. In 2021, our office conducted an investigation of cannabis and liquor retailers' privacy management programs to determine how well these retailers were complying with PIPA. The investigation found that many of the retailers did not have privacy management programs or policies and practices in place to be able to protect personal information. Our report ultimately reiterated the importance of privacy management programs for organizations, and the findings were consistent with our office's guidance on privacy management programs. But now you may be thinking, how do I develop a privacy management program and what needs to be included? So that's what we'll see next. We have 10 core recommendations in terms of how to build a privacy management program. First, it all starts with getting buy-in from the top. It's essential that senior management fully support the development of a privacy management program, including providing the resources necessary for it. Next, organizations should appoint a privacy officer. This is the person at your organization who will take responsibility for handling privacy complaints and related issues and ensuring compliance with relevant privacy laws. Next is looking at reporting structures. The right people need to know how the program is structured and whether it's working. Building this in by design can support in the appropriate oversight of the privacy management program. Fourth, we have the personal information inventory. This will help you identify what types of personal information you collect, how sensitive the information is, and how you're storing that information. It's difficult to appropriately manage personal information without first knowing what information you have available to you. Next is privacy policies. Organizations should develop privacy policies and procedures that govern the collection, use, and disclosure, as well as storage or security of personal information. These policies should allow the organization to comply with all of the requirements under PIPA. Next is privacy training. You'll need to train employees on the policies and procedures that are in place and the responsibilities under them to protect personal information or otherwise appropriately handle it. Number 7, we have the breach response process. It's important to put a plan in place to respond to privacy breaches. Having this proactive plan in place will allow your organization to more effectively respond if and when a breach should occur. 8th is establishing privacy protective rules around service provider management to ensure that there are appropriate contractual controls in place when you're outsourcing services to another organization or entity. Next is looking at identifying and assessing privacy risks. This will allow you to identify what risks are associated with the information you collect, use, or disclose, and how to respond to mitigate those risks. And then finally, continuously reviewing and revising the program. This could include, for example, conducting privacy audits and assessments regularly to always be on the watch for any new privacy risks and trends, and to allow you to review and revise your program to make sure it's responding to the current threats. So that's all for privacy management programs for now. Another topic that we are often asked to speak about is how PIPA protects employee personal information. We spoke about this briefly at the beginning of today's presentation, but again, employees also have a right to privacy in the workplace, which Canadian courts have upheld many times. As discussed earlier, PIPA applies in very specific ways in the employment context. So now let's dive into that. As we mentioned, PIPA defines employee personal information as personal information about an individual that is collected, used, or disclosed solely for the purposes reasonably required to establish, manage, or terminate an employment relationship between the organization and that individual. For example, we found in a case that information gathered by an employer about an employee's location and behavior using GPS and remote sensing could be considered employee personal information, not solely information about the device or the vehicle. But be careful, not everything about employees is employee personal information. Contact information is not considered personal information under PIPA, which includes information that allows a person to be contacted at a place of business. You can think of contact information as the information you would generally find on a business card, for example, an individual's name, position, title, business telephone number, or business address. The important thing here is that the business contact information is used to contact an individual at a place of business. For example, a person's home address could be considered their business contact information if they run a daycare out of their home. Next, we have work product information, which is also not considered to be personal information. This is information that would be generated during the course of an employee's work, like a guidance document that an employee drafts in the course of their day-to-day work. The guidance is considered their work product, not their personal information. So if they quit, for example, they cannot turn around and request a copy of their guidance document under PIPA because it's not considered to be their personal information. So, what are the rules around the collection, use, and disclosure of employee personal information? Well, organizations can generally do more with employee personal information without the consent of their employees than they could with other personal information. Organizations should consider the collection, use, or disclosure of employee personal information, though, when developing and following policies and practices to comply with PIPA. If an organization wants to collect, use, and disclose employee personal information without consent, first, they need to be able to prove that this information is necessary for establishing, managing, or terminating an employment relationship. If it's not necessary for these purposes, then it wouldn't meet the definition of employee personal information. Next, organizations would need to prove that PIPA authorizes the collection, use, and disclosure, like regular personal information, which we've talked about earlier. In addition, organizations need to notify the employee that they will be collecting, using, or disclosing their employee personal information without consent, and they must identify the purposes for doing so within this notice. That notice needs to be provided to employees before the collection, use, or disclosure of the employee personal information happens. It's also relevant to note, though, that PIPA does not require employers to give notice to employees in all situations. For example, if an employee is under investigation by the employer and telling the employee this would compromise the investigation, then the employer would not need to give them notice. Best practice is to record why an organization decided not to tell an employee that it was collecting, using, or disclosing their personal information, and under what authority in PIPA the organization decided not to provide the necessary notification. One of the common questions that comes up when we're talking about employee privacy rights is the question of employee monitoring. Indeed, an organization is entitled to ensure that employees meet productivity standards and that its employees actually work the hours for which they're paid. However, there are some limits to the ways in which information can be collected, used, and disclosed. We're now going to talk about the delicate balance between privacy and employee monitoring. Surveillance systems are now appearing in the workplace, continuously collecting personal information of employees and customers. When an organization's use of surveillance systems involves personal information, as it does in most cases, the use of the surveillance system must comply with PIPA. For example, new smartphone applications have made GPS tracking an easy way to monitor employees. By installing an application on an employee's phone, employers can track an employee's every movement. GPS tracking devices installed in employer-owned vehicles can also include other monitoring and sensing technologies that can track and report more than just a vehicle's location, but also things like vehicle braking information, seatbelt indicators, and even driver behavior. Employees have a right to make a complaint to our office if they feel their personal information, which includes their employee personal information, is being collected, used, or disclosed in a way that does not comply with PIPA. The question of employee monitoring has been looked at in many orders of our office. For example, in 2016, our office conducted an audit looking at video surveillance in a medical clinic. In this case, the clinic had set up video surveillance equipment in the lobby, hallways, back exits, and fitness room, and they were collecting the personal information of their employees, customers, and others. The surveillance equipment operated on a continuous basis, all day and every day. and audio recordings were also collected. Ultimately, our office found that the medical clinic's use of video surveillance equipment in this case was unreasonable and not authorized by PIPA. There was not enough evidence that a safety or security problem existed such that it would be reasonable or appropriate for the clinic to monitor and record employees, patients, contractors, or others who may be captured on recordings. So now, let's dive deeper into those recommendations as they are applicable to all organizations that want to do employee monitoring. In order to make sure that the use of surveillance equipment complies with PIPA, we recommend the following things. First, employers must carefully consider the potential privacy harms when considering the use of video surveillance. Video cameras cannot and should not replace adequate employee supervision. In other words, video, because of its intrusive nature, should be a last resort after less intrusive measures were attempted first. Organizations should notify the employees of the use of surveillance equipment. Second, the use of employee monitoring software should not result in the overcollection of personal information about employees. This overcollection can happen through a variety of ways. For example, there could be planned means, which could include the specific use of employee monitoring software to verify that employees work during their working hours, or unplanned means, which could include things like network firewalls that monitor website and email traffic for the purposes of securing your network. We recommend to limit the time your surveillance is active and the area under surveillance. For example, there's a higher expectation of privacy in a washroom, so cameras should not be installed in those locations. Third, employers need to make sure that the information is collected for purposes that a reasonable person would consider appropriate in the circumstances. For instance, in most instances, PIPA would not authorize continuous real-time monitoring of employees outside of work hours on their professional smartphones. Even within work hours, continuous real-time monitoring may not be reasonable to manage an employment relationship. Organizations should also destroy recorded images when they are no longer needed for the purposes of collection. Fourth, establish organizational measures around surveillance. An assessment should be completed prior to implementing an employee monitoring program, where the appropriate authority to collect the information would be identified. Even if it's not required under PIPA, building a privacy impact assessment can be helpful. Privacy impact assessments help to identify whether a program or activity your organization is undertaking is authorized under PIPA. You're welcome to submit a privacy impact assessment, or PIA, to our office for review as well. We've also developed a template called the Privacy Impact Assessment Template and Guide on our website. Additionally, you may want to consider completing a security, threat, and risk assessment, depending on whether new technologies are used to facilitate the employee monitoring or existing technologies are used in new ways. If you're unfamiliar with security, threat, and risk assessments, the BC government has information on its website, and you can refer to that website or contact us for more information. Organizations should also develop a surveillance policy and limit access to recorded images to authorized individuals only. Organizations should consider individuals' rights of access, for example, considering how you would provide individuals with a copy of their image or recorded video, and how you would remove personal information of third parties who may be captured in those images or videos as well. Organizations should store any recorded images in a secure location and follow a routine destruction policy so you don't keep excessive unnecessary amounts of personal information longer than is reasonably necessary. Organizations should also periodically reevaluate their need for video surveillance. Of note, these recommendations would apply even outside of the employment context. As an example, our office issued a 2021 order following a complaint from a resident of a strata building that the strata corporation was inappropriately collecting and using personal information through its video surveillance equipment. The purpose of the surveillance was to prevent and investigate property damage in the parkade. Because property damage is a legitimate issue that can most effectively be addressed through video surveillance, this purpose was considered reasonable and appropriate. However, the strata also collected and used video surveillance for another purpose, which was preventing and investigating property damage in the gym, swimming pool, and hot tub areas. The strata corporation was ordered to stop collecting and using personal information for these additional purposes, as these areas are considered more private and there is only a single documented incident of property damage in those areas. So, as you can see, the question of monitoring is not specific to employees, but it applies to a lot of different contexts. So that covers the bulk of our content. Our office also publishes guidance to support organizations in meeting their requirements under PIPA. We work to keep these resources as up-to-date as possible. There are a few different ways that our office can help, though. Organizations interested in consulting with our office can reach out to our office for a consultation. Please note that we do not approve or endorse any programs or solutions, nor do we provide legal advice. Our comments are just that, comments, and while we aim to help as much as possible, it remains the responsibility of the organization to ensure that they comply with PIPA. We also receive general questions through our Info OIPC email box, or you can reach out to us directly with any questions you may have. Our email is info@oipc.bc.ca. We also produce educational materials. For example, the Privacy Right webinar is a series of resources for organizations to promote compliance with PIPA. We encourage you to consult it on our website. Organizations are also encouraged to voluntarily report privacy breaches to our office. Our office can support you in managing these privacy breaches to provide the best opportunity to meaningfully mitigate risks of a breach. That brings us to the end of the presentation. Thank you for joining us for this look at BC's Personal Information Protection Act. Please remember that the OIPC is here to help, and we welcome your access and privacy-related questions.